Thank you all for joining us this morning. This is the CLC Community Efficiency Leadership Coalition webinar series. And today we are going to discuss the state of environmental law in 2025. Our presenter is Neil Kucera, an attorney with the Hays County Criminal District Attorney's Office. And Neil also teaches environmental law at Texas State University. We'll explore the state of environmental law here right now in 2025. It's changed quite a bit, and also the history and demise of Chevron deference. So this is fantastic, whether you're a legal professional, policymaker, student, or an advocate in this realm. So this webinar will hopefully provide valuable insights in the past, present, and future of environmental law in the administrative state. Before we get started, I have a few slides to share, and then we'll kick it off. So I do want to mention that this webinar series is supported by SPEAR, the South Central Partnership for Energy Efficiency as a Resource, the State Energy Conservation Office, also known as SECO, and HARC. It's Houston Advanced Research Center. So thank you for your support for the webinar series. A little bit about ourselves and who is SPEAR. We're one of 6 regional energy efficiency organizations. We're a member-based nonprofit 501c3 organization. We have 50 plus members from right across the section of energy efficiency industries. And our mission is to accelerate the adoption of advanced building systems and energy efficient products and services in the South Central United States. And I just want to also mention that we have several really great programs, including building codes with training, building operator certification program, and then we also do some policy work. So we're a 501c3, so the way we do perform our policy work is through providing resources and education, and you're welcome to look at our website and follow this legislation that's related to energy. And then finally, my work is in local governments and community engagement and really kind of developing peer-to-peer network, as well as training and facilitating training sessions, and then supporting public sector energy efficient projects. Some housekeeping is today this event and the webinar series is recorded and then put onto our YouTube channel. Our SPEAR YouTube channel has over 180 videos, educational videos. I highly recommend exploring them. Questions are welcome to be placed in the chat. You're also welcome to use a Q&A and utilize the chat for conversations. And Neil is very excited about presenting, and he is a wealth of information. We'll also have a survey that I'll place in the chat, and along with a follow-up email. Please respond. It helps us expand our program. And all ICC CEUs will be mailed out within 3 days. In order to receive those CEUs, though, you do need to respond to our survey. And then just to kind of give you, if we have more events going on, please check out our website, eepartnership.org, and we have a calendar, several events coming up and workshops. So please explore. And then we also have a monthly newsletter, the CLC newsletter, that really focuses on public and we focus on what's going on, as well as our members and what they're doing, because we have a community efficiency leadership coalition. And so you can explore what our regional partners are doing, as well as we have 3 other newsletters that focus on codes, policy, and then SPEAR overall. And I will include the slideshow when we follow up with an email. And then we have several resources, a reporting guide, a city efficiency toolkit, a Texas Energy adoption toolkit, templates and messaging guides for policy, and then our YouTube channel. So without further ado, I am going to kick it off to Neil, who is a friend, a mentor, and really just very excited about him sharing his knowledge today. Thank you so much, Neil. I'm going to stop sharing and turn off my video. I'll leave my audio on for a moment so that we can be on the same page when we see your slides. So right now I can see everything. So if you want to There we go. It's in slide mode. Fantastic. Thanks.
Okay, everyone. So happy to be here. My name is Neil Kucera, and just want to tell you if there's anything that I say that's wrong or controversial, I will blame it on my AI chatbot, which is sitting right beside me. And if that doesn't work, it's Sean's fault, since I'm being recorded. Uh, so 2025, I don't know if any of you recognize this, but this is an album cover from Billy Strings, and it's titled Turmoil and Tinfoil, which is really a good way to describe the state of environmental law here in 2025. In case you haven't noticed, we do have a new administration in place, and everything, it's almost going to be the first 100 days, has been turned on its head. And it seems like every day we have something new thrown at us: deportations, tariffs, breakdown of long-time alliances, federal government cutting, DOGE, etc. And don't think that the environment has escaped any of this. We have a lot of headlines, if you're paying attention, about things going on in the realm of environmental protection and environmental law. Just show you a few of them. Here, this issue of protecting critical habitat has been settled law through the Babbitt versus Sweet Home case for the last 30 years. Now there's talk about changing that. Here is something that was very disturbing, kind of the butchering of the Interior Department. You realize what's included in the Interior Department is Fish and Wildlife Services. And I even read something this morning that now the Department of Interior is proposing opening up national monuments, not just federal land, but national monuments to mining and forestry interests. Again, disturbing. We see that the EPA is proposing some more limitations on what constitutes water in the United States, and that definitely affects wetlands. In 2023, the Supreme Court in the Sackett case, they undid 40 years of established laws defining waters of the United States that both the EPA and the Army Corps of Engineers can regulate under the Clean Water Act. And apparently there are movements to even limit it further. Coal plants and other industrial polluters, they're getting a reprieve apparently under the Clean Air Act as far as emissions of soot, greenhouse gases, and other things. Now, you notice a lot of these headlines will pertain to the EPA. EPA, of course, began operation in December of 1970, signed by an executive order of Richard Nixon. It was basically ratified by both the House of Representatives and the Senate. The EPA is led by an administrator. They're appointed by the president. They're approved by the Senate. Now, the EPA is not a cabinet department per se, say like the Department of Interior, but the administrator of the EPA traditionally has been given cabinet rank. And so there are regional offices, 10 regions, 27 laboratories around the country. And if you know anything at all about the EPA, you know they do environmental assessment, research, and education. They also maintain national environmental standards, and they enforce these. So go back to just 2023, there were over 16,000 full-time employees with the EPA, ranging from engineers to scientists, environmental protection specialists, people in the legal field, public affairs, financial, information technology, etc. And if you've been following the headlines, you can see that all these things are subject to large-scale cuts. Now, the new director of the EPA is a former representative from the Long Island region of New York State named Lee Zeldin. And there's an article that makes quite interesting reading. He was, as a representative of his district, fairly moderate when it came to environmental protection. He supported bills to address forever chemicals. He supported bills to prohibit oil drilling, off of both the Atlantic and the Pacific coasts. In 2020, in fact, he voted for a bill that would have drastically slashed the budget of the EPA. And the people in his district of New York worked with him very well. He helped save an island named Plum Island from being sold to the highest bidder. He worked with the Army Corps of Engineers to protect coastlines. He was very involved in coastal risk reduction projects. Again, a pretty moderate guy when it came to the environment. However, once he was appointed to the EPA, he apparently did not want to be outdone by Elon Musk. So on March the 12th, he makes a grand announcement here. And this is kind of interesting, saying that this is the biggest day of deregulation. And what you get from reading that is, well, the EPA's mission has changed. It's no longer protecting the environment first and foremost, but it's protecting jobs. It's protecting the fossil fuel energy industry. It's battling the, quote, climate change myth. And when he made this announcement, there were several things. And when I send the slides later, you can look at these things. But notice a lot of things are being, quote, reconsidered here. Any regulations on power plants, anything that disturbs the oil and gas industry, anything that has to do with risk management programs is being reconsidered. Greenhouse gas reporting is being reconsidered. And I find this particularly interesting. Again, the core mission of the EPA, in my understanding, since 1970 has been to protect the environment. But all of these things are being reconsidered. And I want to direct your attention to this one right here. It says directing enforcement resources to the EPA's core mission, relieving the economy of unnecessary bureaucratic burdens that drive up the cost for American consumers. Again, that is very, very puzzling, because I was not aware until this came out that was the core mission of the EPA. Now, if you want to keep up with everything that's going on with the EPA and the regulatory world, Harvard, and yes, I'm mentioning Harvard here, has an environmental and energy law program, and they have trackers that will keep you up to date on everything that the EPA and other energy and environmental agencies are doing. Now, I'm going to show you this again a bit later, but if you just look at some of the summaries, it's very, very eye-opening. And you go to something called the regulatory tracker, and it covers both environmental protection and actually clean energy deployment. And so you can get the latest regulatory news from this website. So let's just go back 8 or 9 months ago, and you will see the EPA and the White House doing certain things. But notice the words that are popping out here. We have proposed, announced, we have issued, released. Things are happening, new rules and new regulations to protect the environment. But now look at it. What do you see as the key word? The key word, of course, is rollback. And I'm not talking about the Walmart variety rollback. Everything that's been done, in fact, in the Obama administration and the Biden administration, is in the process of being rolled back. Now, these things do take some time, but it's kind of disturbing to see the entries lately being all rollbacks. Now, the common thread here is that they all involve agencies, okay? There are different types of agencies, of course, in the country. There are the cabinet departments, like the Department of Interior that we talked about, but there are independent agencies, and the EPA is one of those. And a lot of these rollbacks involve federal agencies. And of course, the United States began with some basic agencies, the Department of State, the Department of War, which no longer exists, the Treasury Department, and other departments. And of course, with the advent of FDR and the New Deal, a lot of the New Deal legislation led to the creation of a large amount of agencies. In fact, during this time period, they were known as the alphabet agencies, and there were about 69 of these. And you had people who were hired for their expertise, and they became lifelong civil servants who, again, entered with expertise and increased their expertise the longer that they worked with an agency. Now, in 1946, Harry Truman signed into law the Administrative Procedure Act. And this was enacted to basically outline some procedures for all the agencies, which, of course, like I mentioned, during FDR's time had increased. So it gives the means by which agencies can propose regulations and establish them. It talks about if you need to get it into the court system, any agency decision, how you do that. That's called judicial review. It's kind of, the APA is considered the Constitution as far as administrative law is concerned. And this has been the cornerstone of U.S. administrative law since 1946. So it's very, very important. And it was in this context, the APA had been on the books for a long, long time, that we had an amazing decade between 1970 and 1980. There were things that were happening in the late 60s, the Santa Barbara oil spill, the Cuyahoga River catching on fire, the advent of Earth Day. All these things led to bipartisan federal environmental statutes. And here's some of them. National Environmental Policy Act, of course, which requires any project that would have a major federal impact to stop and look and consider environmental matters before they proceeded. We had, of course, the Clean Air Act, which talked about unauthorized emissions of air contaminants. We had the Clean Water Act, which governed any discharges, wastewater discharges into waters of the United States. We had the Endangered Species Act. We had the Safe Drinking Water Act. RCRA, which is the Resource Conservation Recovery Act. Here in Texas, it's known as the Solid Waste Disposal Act, right there, covering both regular solid waste and hazardous waste. We had CERCLA, and that stands for the Comprehensive Environmental Response Compensation and Liability Act, also known as Superfund, whenever we have hazardous waste that's been released into the environment. So those were all of the major acts that happened in a decade. It's quite amazing. Now, what happens is when Congress enacts these statutes, it leaves the details up to the agencies to create a program, to run the program, and to enforce the regulations that are part of each one of these programs. And that's why over the decades, agencies became known as the fourth branch of government. We have three branches of government, of course, the executive, legislative, and judicial. And so think about what agencies do. They do legislate because they create things called rules or regulations. They enforce in their permitting program, issuing notices of enforcement and notices of violation. And to a large extent, they interpret their own regulations. So they are fulfilling in their tasks some of the purposes that all three branches do. And that's why they're called the fourth branch of government. So this is where most environmental law takes place. I sometimes have students who say, hey, I want to go into environmental law. And so I tell them what you need to do is become familiar with administrative law, because if you practice what's called environmental law, you're going to be practicing administrative or agency law there. And so that's the practice of environmental law, the real day-to-day practice. It takes place on the agency level. And of course, agencies were created to be more efficient, and they were created to encourage public participation. And that has not changed since 1946. So when you look at the nation as a whole, there's lots of federal agencies that could be involved in the environment. The Department of Interior, like I mentioned, sub-branch is the Fish and Wildlife Service, the Department of Energy. All of these are federal agencies. But of course, the agency that everyone thinks about when it comes to environmental protection is going to be the EPA. So there's a whole agency regiment that occurs on the federal level, but each of the 50 states has its own set of agencies and procedures, including Texas. So you really have 51 systems going on at once. The federal system, and then each state has its own system. Now, of course, when we think about environmental protection in Texas, the lead agency, not the only, but the lead agency is going to be the Texas Commission on Environmental Quality. And when we go through agency procedure and practice, as we will in a few minutes, I'm going to go through what we do with the TCEQ. And because all states follow the Administrative Procedure Act, most of these procedures are going to be common to the other 49 states and definitely common to what goes on the federal level. So just as a little primer, since I told you environmental law is practiced on the agency level, let's look at the powers that agencies exercise. And we're going to do this in a very generic way because I do not have the time to go into great detail, but this is what agencies do when it comes to the environment. Primarily, they are going to be making rules, and then once those rules are made, they are going to be regulating. Now, this rulemaking, and I'll go through it very briefly, comes about as a result of something called notice and comment. And then the regulation involves two things: permitting those that are in the program, and then enforcing against those who fail to follow their permits here. Now, this is how rulemaking is going to happen. And there's a procedure here. And again, it's followed on the federal level, it's followed in all 50 states. The very first thing when an agency, let's say like the EPA or the TCEQ, wants to promulgate a rule, they will give the public notice. And it's typically published for the first time in a publication called the Federal Register, and here in Texas, the Texas Register. That's published every Friday here in Texas. You can find that on the Secretary of State's website. They keep current issues of the Texas Register. So you can find out what any agency is proposing as far as a rule by reading the register there. Now, at the end of that first notice and publishing of the rule, they're going to ask the public for comments. Typically, you can send these in via email or other means to the clerk of that particular agency. And this is not limited to just a few people. Anybody can comment on these proposed rules. I've done it before. You can do it if you keep up with a rule and it's something that's interesting to you or even disturbing to you. You can have a comment. Now, by law, and that's in the APA, the agency has got to consider all the comments. And again, I've seen this work with the TCEQ. A number of years ago, there was a rule that was published, and we in Travis County had some issues with it. And so I was tasked with sending in comments on behalf of the county to the TCEQ. And they actually considered the things, because when they adopted the final rule, they have to respond to each and every comment that they receive, and they have to explain why they went with this comment and changed their proposed rule, or why they didn't change the proposed rule. And so I sent in 2 comments on this particular piece of regulation, and it was actually reflected that they changed the wording of the regulation based on the comments that we had submitted. And so that's kind of good to know that someone is actually reading these things. So when I talk about public participation, no one is prohibited from participating in these things, but you have to know what rules are being proposed. Again, on the federal level, it's going to be the Code of Federal Regulations. And on the state level here in Texas, it's going to be the Texas Register. And if I said Code of Federal Regulations, what I meant was the Federal Register. Because when a rule is finally adopted, then it goes into the regulatory publication. Federal level Code of Federal Regulations, and with the state, it will go into the Texas Administrative Code. And most of your environmental regulations are going to be found in 30 Texas Administrative Code. So that's the rulemaking procedure. Now, once these rules are intact, permits are being issued. And so what the agency does is they look at this enabling statute. Maybe it covers clean air, maybe it covers clean water, maybe it covers solid waste. But you see, all right, who is contributing to the pollution there that we're trying to prevent? And so you base a permitting program based on who is contributing to the problem right here. So the agency will look at all these activities. Of course, we have a lot of private activities. A lot of us own property. We have our houses and everything, but that's not really what the agency is looking at. They're more concerned with commercial and industrial activities there. And so permits will have regulatory parameters. In other words, how much can you emit of what toxic substance? How much can you discharge of these wastes or pollutants? And there's a whole process that goes on. A lot of people call permits permission to pollute, and that's essentially what they are. But they do know the limits, and the EPA sets the minimum standards for each state in the country. And so looking at these activities and these permits, let's start out with the most lenient and go to the let's start out with the least lenient and go to the most lenient. Sometimes you look at certain activities and they're exempt. They're called de minimis. So for instance, here in Texas, if you are crushing a piece of equipment and there are a few drops of oil, which normally would even be a felony, just a few drops of oil, those are considered to be exempt because if you do it by the rules, they say you will have a minimal impact on the environment. So there's lots of these kinds of activities. There are other things called permits by rule, and you'll see this mostly in the air pollution program. So the TCEQ publishes a rule of things you can and can't do. And as long as you follow that rule, you're not going to get a document called a permit. You are deemed to be permitted by following the rule. And so lots of these things would be like auto body repair shops, surface coating operations, certain gasoline dispensing facilities. As long as they follow the rules, they're deemed to be permitted. Then you have these things, and again, you get stormwater permits, hazardous waste permit. They're called general permits. In other words, we have activities that are common to a lot of things that are going on all over the state. So we're not going to give your facility an individual permit. We're going to have a general permit for everyone who's doing what you're doing across the state. And as long as you follow this general permit, you're going to be fine. And then certain larger facilities have to get individual permits. And these things are longer, more expensive, and take more time to get. The permitting process, again, is governed by the APA. So a facility sends in an application there. Once that application comes in, the TCEQ publishes that once again in the register and gives notice. I mean, if you're living next to a site that now wants to start a concrete batch plant, you're probably going to want to know when someone's applying for a permit there and be put on notice. So just like with rulemaking, the agency will elicit public responses there. And in fact, in a lot of instances, if there's enough people who are interested, or you can get your state legislature interested in it, you can request a public meeting there. And that's where a lot of these responses, positive and negative, get aired out. Now, you always have to file written comments, just like you do with rulemaking, and the agency has to consider these things. And in the end, they're either going to approve the permit, maybe with some modifications, or they're going to deny the permit. And again, this goes across the spectrum, no matter what media you're talking about. It could be air, it could be water, it could be solid waste. The permitting process is basically the same. All right, little joke there. There's Larry, the cable guy. He's not really an EPA inspector, but we have enforcement. So we've made the rules. We have started regulating by creating a permitting program and specific permits for specific facilities and specific activities. And now we have to enforce the parameters of those permits here. So, of course, this is what I do. I'm in enforcement, not with an agency, but with a local government. The goals, whether you're with an agency or local government or the EPA, are basically the same. First and foremost, we want to stop the violations when they occur. If there's been damage as a result of these violations, we want it remediated. We want it cleaned up ASAP. Then, depending on the circumstance, we will penalize whoever the violator is, and we want to make it a penalty that will deter others. Trust me, word gets around amongst violators, even facilities, that, hey, the EPA, hey, the TCEQ, hey, Hayes County, they're not playing around when they do enforcement. So we better mind it, because look at what happened to this facility over here. Look at this fine that they had to pay. So those are the goals. Stop it, clean it up, penalize the offender, but then provide a deterrence to anybody else who would think about doing these things. You may ask, well, how does an agency even find out that there are violations? I mean, when's the last time you've seen a TCEQ inspector walking around? They only have so many to go around. The EPA even less. Well, believe it or not, a lot of these are by self-reporting. And so what it is you have an obligation if you have a violation, and it might even be an accidental violation, an upset is what we call it. If you report it, usually the agency works with you, and punishment, if any, is going to be pretty minimal right there. And so what we say is, if you do self-correction, we as the agency are going to show you some leniency. And so a lot of people will take the agency up on that offer. And so we don't want people scared to report violations. We don't want people hiding violations. We want them to report with the understanding that we're going to be a little bit more lenient. Sometimes third parties will complain. Somebody's driving by, they see something, they experience something, and it might even be right next to where they live, where their children go to school, and they will call the agency and report this. I always show this because we have gotten so many of our complaints from neighbors who apparently do nothing all day except watch. They are watching things, and again, this is good. We need somebody to provide a kind of a watchdog effect there and report things. Some of these things turn out to be true. Some of them are not true, but we appreciate getting the complaints anyway. And then I'll show you this. Many complaints come into an agency because of competition. In other words, you have a facility that is not following the rules, and facilities that do follow the rules get resentful about that. And so they say, well, we're spending money. We've hired personnel to do the right thing, but look at them. They're operating and they're making money by doing the wrong thing. So I'm just going to report them. And so that happens lots of times. Your competitors will report you here. And sometimes it's by routine inspection. When I say the EPA and the TCEQ don't have that many boots on the ground, doesn't mean they don't have any, because they will go around to different parts of the regulated community and do inspections, and they will just show up and do these things right here. So what happens in the enforcement process? Well, most of it is kind of informal. Okay, people will take care of this stuff once they're notified by the agency. At least that's what we hope. Sometimes when people don't want to correct the problem and do the right thing, you have to start a formal enforcement process. And, there's lots of violations out there to look at. There can be just technical violations, or there can be substantive violations, things that actually cause major pollution. They can be large, they can be small. Sometimes it's a result of an accident, and sometimes it's intentional. Again, when we find that violators are hiding what they've done, they don't want to talk about it, they're being evasive, that starts going from accidental to intentional. And when you start talking about intentional, you not only get administrative penalties, you can get civil penalties and possibly criminal penalties too. Now, how are these penalty amounts figured out? Well, we create a matrix, and I'm going to show you a couple of really simple ones from the EPA. So here's one for RCRA, solid waste, up at the top, and then there's one for CERCLA, which is Superfund, down there. Now, again, what you need to do is put in a bunch of factors into your matrix. Like, are these people, did they report themselves, or did someone have to report them? Once they were aware of the violation, are they making good faith efforts to remediate this, or are they just continuing with their ways? You look at the past history. You used to have an investigator, Sean knows him, Doug McDougall, and he would come in and with a violation, and he's saying, Neil, this is not their first rodeo, which means we've had problems with them before. So if you have a facility that has problem after problem after problem, the matrix for penalties is definitely going to change. But there is a pattern to figuring out these penalties. Now, in all these things, and especially with permitting and enforcement, somebody's going to win and somebody's going to lose. That's the case in just about everything. And if the losers of this, whether you got your permit denied or you got a penalty that you feel is excessive, or the permit was approved and you as a neighbor didn't like it, whatever, as long as you follow the correct procedure, and there is a procedure, you can request what's called a contested case hearing. Yes, the people at the agencies, the executive director, they've made decisions about permits, about enforcement issues, but you don't like it for some reason. And so within agencies, you can request this contested case hearing. And so this is all about administrative law judges. The EPA has a bunch of them. In Texas, with the TCEQ, we have an agency that does nothing but contested case hearings, and it's called SOA, the State Office of Administrative Hearings. So it's kind of like a little civil trial there. You can get lawyers, parties file motions, you introduce evidence, you can have all these things, and it goes through that ALJ process. But guess what? Ultimately, at the end of that process, the ALJ is going to rule in your favor or not rule in your favor. So what happens if the loser is still unhappy? Well, this is one thing you can do, and a lot of people have taken to this. You can start drinking and drinking now and drinking heavily. Probably not a good thing to do to further your cause. But we could be good Americans. We do live in a litigious society, and we can decide we're going to go ahead and take this thing to court here. So this gets us to what's called judicial review. And this is when administrative decisions, and you've gone through the whole process, this is when they now get into the court system for courts at law to decide whether the agency has done the right thing or not. Now, how do you get into there if you're the loser? Well, there's three things. And again, I'm not going to go into great detail because this could take up hours and hours. But here are the three threshold requirements: standing, rightness, and exhaustion of administrative remedies. Now, just very, very briefly, I'm going to explain this. Standing means you are the right person in court for the right reason, because Article 3 of the Constitution says court shall only hear cases and controversies. And so we don't want to let anyone and everyone into court, because some issues just don't belong in court. So let's say tomorrow, after hearing this webinar, Sean has decided that this is terribly boring and it was a real waste of her time. So she goes down. No, let's even make it better. Sean told her husband that this was a complete waste of time. So her husband goes down tomorrow to Hays County District Clerk and files a lawsuit against me because this webinar was long and boring. Now, a lawsuit's been started. I've been served. I'm not going to go through a trial with this. I'm going to tell the judge that Sean's husband does not have standing. He's not the right person, and he's not in court for the right reason. Now, I would even say that if Sean filed this case. So again, standing is really, really important. You have to have an injury. You have to have causation, a connection between the injury and what the person supposedly did that was wrong. And you have to have redressability. In other words, can a court cure this problem through a court action? I remember there was one lawsuit someone filed against the devil for causing problems in his life. And of course, when the court was dismissing that, they said, they couldn't, this person didn't have standing, there was no redressability, and they couldn't assume personal jurisdiction over the Prince of Darkness. Anyway, so standing, the right person for the right reason. Oh, let's go back to this. Rightness, just really, really briefly. So this means the issue is ready. In other words, has this thing gone through the administrative process to the extent that the issue is ready for the court to hear? And then the third one is exhaustion of administrative remedies. In other words, there's lots of hoops you have to jump through, asking, say, motions for rehearing, filing motions to overturn. In other words, the court, before they will agree to hear your case as a loser on the administrative level, they're going to want to ensure that you have gone through every agency avenue possible to seek redress of your problem. Okay? Standing, rightness, exhaustion of administrative remedies. All right, now let's say you've gotten to that, and you've gotten a court to agree to hear your case that you think you were done wrong by the agency. How much do courts want a review of what the agency has decided? Well, they could do a broad review. They could nitpick every single thing that the agency has done. Or they could do a narrow review. In other words, they could leave the agency decision alone, basically, unless it's absolutely off the mark here. So when contestants are asking a court to review, it's going to come down to, does the court want to make a broad review, or do they want to make a narrow review. Now, this issue we thought was decided many, many years ago in the Chevron versus the Natural Resource Defense Council case. And basically, the background of this is not that important. But what had happened was the EPA decided to enact regulations under the Jimmy Carter administration and enforce them in one way. You had a new administration come in, and that was the Ronald Reagan administration, and they decided to enforce these in a less stringent manner. And so people were wanting to force, and by the way, this is really interesting. The EPA director at that time was Ann Gorsuch, who is Neil Gorsuch's mother. Neil Gorsuch, of course, is a current member of the United States Supreme Court. So activists were wanting, with the NRDC, were wanting the court to tell the EPA, you cannot use these new rules. You have to use the ones that make the most sense to us. Well, guess what? The Supreme Court, and it was in a unanimous decision here, decided, hey, we may not agree with what the EPA did as far as narrowing the protections under the Clean Air Act, but it's not a matter of whether the courts agree or disagree. If the statute is vague, if there's room for argument on both sides of the statute and it's a little bit confusing, we're going to defer to what the agency decides. We're not going to second guess this. And that's known as Chevron deference. The courts are going to give deference to agency decisions unless that statute is crystal clear and the agency has disregarded it, and they use the term in an arbitrary and capricious way right there. So look, here's the way it works. The court will take a broad review of agency actions if this statute is absolutely clear and absolutely detailed on the issue. That means the agency didn't have a whole lot of discretion because Congress was pretty clear there. But let's say the statute doesn't give a whole lot of details, and frankly, a lot of environmental statutes and others don't give a whole lot of these details. Let's say it's silent and there's no details about it. Well, that broadens what an agency can do. And by the way, this includes not just the EPA, but any agency involving any piece of legislation. So the general rule, the more vague a statute is, the greater discretion an agency has, and therefore, when it's reviewed by a court on judicial review, that review will be narrow. This is the gist of Chevron deference, and it became a thing, okay? And so agencies from 1984 on were continuing to make decisions. And once again, they had lifelong experts in these areas who could make informed and intelligent decisions here. And a court would only reverse those agency decisions, again, if it was completely off the mark. And so, they developed that agency expertise. And again, there had to be an egregious error, arbitrary and capricious. So judges across the country, after the Chevron decision, they were pretty relieved there, actually, because they didn't have to decide these things anymore. They could just decide if an agency had made a permissible decision. And so this approach became common in the federal level in every district court and every court of appeal. They had the same approach. And why the justices on the appellate courts were so relieved, because they didn't have to be experts in these technical issues and these scientific issues. They could rely on agencies like the EPA to make reasonable decisions in most instances. So again, I'll show you this little thing. I didn't create this, but I gleaned it here. So right here with Chevron deference, you're looking at courts versus agencies. Who has the expertise comparatively when it comes to that subject matter? Well, it's going to be the agencies. And so then what Congress does, because of this expertise, they delegate the details of this legislation to agencies. And so under Chevron deference, courts are going to recognize this expertise, and that's why they're generally going to defer to agencies. Okay, so as a court is reviewing something on judicial review, you were unsatisfied with the agency decision, you've done standing, ripeness, exhaustion of administrative remedies, you're now in court. So there were a couple of steps. The first thing that the court would ask is the law that these regulations based upon, is that law ambiguous? If not, the agencies are going to be second guessed by the courts because Congress has clearly spoken. And so the agency didn't have much discretion. But if, as in most cases, the answer to the question, is the law ambiguous? If that answer was yes, the agency most likely is going to prevail, because all the court is going to say is, was the agency decision permissible? Not was it right, not was it wrong, was it permissible? So again, this became the rule that all courts followed beginning in 1986 from a unanimous decision. Here's Justice Scalia, really interesting. He was from 1986 to 2016. They call him the intellectual anchor of the court because he always had originalist positions and textualist positions, and he was known as the leader of the court's conservative wing. And you know what? He was a champion of Chevron deference here, because when Chevron first came out, it was regarded as a conservative doctrine, because what it's saying is, quote, activist courts cannot undo agency decisions from a conservative administration, like the Reagan administration. So courts don't have that expertise, and no matter what the court thinks is the right answer, they should defer to the agency's answer. And this kind of thinking became prevalent not just on the federal level, but on the state level too. And so most states began to do this. So let's say a group of people, organizations, industries, they don't like an agency decision. Well, guess what? The democratic process in the United States ensures that every 4 years or every 8 years, we're going to change the chief executive. Okay. And that chief executive, when they come in, they're going to adjust agency leadership to reflect their values and their priorities. So just wait around a little bit and things will change. And so you say, oh, well, agencies never change. Yeah, they have lifelong employees who practice things, but the leadership will definitely change in different directions. And this reflects out the democratic process. I always tell people this when they look at elections, they're looking at silly issues sometimes. One of the things I look at when I'm choosing to vote for a president or even a governor is what are their priorities as far as their appointments? Who are they going to appoint to head these agencies? Because a lot of the day-to-day decisions that affect the environment and affect us are going to be made by these agency heads who the executive has appointed. So that's a really big issue when it comes to voting time. So again, Chevron deference. And look, judges, whether they were on the conservative or the liberal spectrum, they used Chevron deference when it suited them. I mean, we had justices. Here's Brett Kavanaugh here, and he's never been a fan of Chevron deference, but it didn't stop him from using it when it suited him. Look at this. So when the agency gave a conservative interpretation of their rules and regulations, he deferred to the agency 81% of the time. But when it was liberal, it fell to 71% of the time. So yeah, we hope that our justices are not going to let political considerations interfere with their decisions, but they often do here. Now, look, Chevron deference was in place, but you would see from time to time courts actually reversing an agency decision. It didn't happen that often for about a 40-year period, but it would happen. Here's one instance. It's Michigan versus the EPA, and the issue was when the EPA is issuing regulations, do they need to consider costs here? And so, in a 5-4 decision, Justice Scalia, who of course was a proponent of Chevron deference, said, "No, I just can't do it in this instance because the EPA interpreted the Clean Air Act unreasonably because they didn't consider costs among a lot of factors when implementing more stringent emission standards." By the way, I actually agree with the Supreme Court in this case. The EPA did go a little bit above and beyond the law as it was written. And we always say bad facts make bad law. And so in this instance, it absolutely did. And so there's one instance where the court overturned Chevron deference, or at least didn't adhere to it. Here's another one on the other side. And again, I agree with the outcome. This is 2007. And what was happening is the EPA under the George W. Bush administration said, we have no authority under the Clean Air Act to regulate emissions of CO2 or, in fact, any other greenhouse gases. And so they refused to do that. And so Massachusetts, along with it was 11 other states and several cities, decided to go ahead and challenge that. And it got all the way up to the Supreme Court. And Massachusetts was saying, hey, EPA, if you look at the Clean Air Act, you're required to regulate what it says, any air pollutant that could endanger public health or welfare. The APA denied that claim. Anyway, it went all the way up to the U.S. Supreme Court. And again, a 5-4 majority. And notice none of these 5 are still on the Supreme Court. What they found was that the rationale used by the EPA for not regulating greenhouse gases was inadequate. Okay. And they did not maintain a reasonable basis when they were avoiding those regulations. So that's what they decided. They understood about Chevron deference, but they said, we're not going to give it in this instance. And so they remanded it back down for the EPA to begin regulating greenhouse gases. So you can see, no matter what side of the political spectrum you're on, from time to time, if you could get a consensus, the Supreme Court would break with Chevron deference there. But let's stay with the year 2007. Change was in the air. I don't know the ages of people who are listening to this, but just go back to 2007. We had an election. Remember these posters? And we had President Barack Obama here. And, we were going through a bit of a recession, but he came into office wanting to revitalize certain things when it came to the environment here. Do you remember what movement arose shortly after President Obama took office? Yeah, it was the Tea Party movement. It's really interesting to study this. Allegedly, the people were saying, okay, we want lower taxes, we want the national debt lowered, we want the deficit lowered, we want government to spend less, and all this. And I, working next to the Capitol, saw several Tea Party things. The funniest one I saw was, tell the federal government to take its hands off my Medicare. I'm thinking, last time I checked, the federal government ran Medicare. Medicare is a federal government program. Anyway, there wasn't a whole lot of sense to this, and it's kind of dissipated and gone in many ways into the mainstream now. But this was the kind of stuff that was going on. And so uh, they're developed this, and I just want to call it a conspiracy theory. The deep state. You started hearing that being talked about in, beginning 2008, 2009, and so forth. This concept has been with people for a long, long time. It's basically that there are unauthorized or maybe secret networks of power that are operating independently of a nation's government there. And a lot of times these involve conspiracy theories. I mean, you could trace back its origins to conspiracies about demons, secret societies, things like that. But basically, this version of the deep state was saying, okay, look, there are institutions in this country, military, intelligence, bureaucratic, involving agencies that are attacking democratic governments. And these are unelected officials, and so they're undermining democracy by working against the people who have been elected. Of course, keep in mind that I said anybody who's elected, especially the chief executive, is free to change the leadership of these agencies whenever they please. But this was starting to develop, and it was centered on agencies in general, the deep state. So this is going on. So in 2013, you started seeing some cases, and maybe the handwriting was on the wall. This has nothing to do with the environment. This case was whether the FCC had legal authority in the way they interpreted the Communications Act. Here, they were setting time limits for state and local governments to approve their zoning requests when it came to, say, wireless network towers and antennas. And cities like Arlington and San Antonio, they objected, saying the FCC didn't have the authority. Well, in that case, the majority ruled that the cities needed to defer to the agency, the FCC. They followed Chevron deference. But guess what? There was a stinging dissent by who is now the Chief Justice of the United States Supreme Court. He said, not just quietly dissenting, he said a court should not defer to the agency until that court decides on its own that the agency is entitled to deference. In other words, we're kind of starting to break up the concept of Chevron deference, and it should be the courts making the decision and not necessarily the agencies. Now, he was in the dissent in this case, but just keep this in mind. So we talked about the Michigan versus EPA case, and I found this little poster, and what they're saying is, look, if even Justice Scalia is doing this, we're seeing Chevron deference starting to be eroded here. So check out the date. There's 2016, and we had an opinion written by a 10th Circuit Court of Appeals judge. It's Neil Gorsuch, who later became part of the United States Supreme Court. And he was always of the opinion that Chevron was not good law and Chevron deference needed to be reconsidered. Okay, check this out. Y'all know who this is. This is Brett Kavanaugh, appellate judge at that time on the DC circuit. He wrote in a law review article that Chevron had no basis in the APA. And he said, look, it's the court that needs to do what? Decide all relevant questions of law, interpret both constitutional and statutory provisions, and determine the terms of an agency action. So you've got John Roberts, you've got Neil Gorsuch, you've got Brett Kavanaugh, all of whom have expressed outright disdain for the concept of Chevron deference. So while all this is going on, law review articles are being written and courts of appeal decisions are being written. The Obama administration says, hey, we're going to battle climate change. Okay. And so we're going to do something called the Clean Power Plan here. And they worked on it, and it was unveiled late in 2018. And I find this kind of interesting to look at. They said, all right, we're going to look at the sources of our electricity and look at them over here in 2013. Okay, we have a lot of coal going on here. And by 2030, we want coal to be down to 27.4%, providing the basis for our electricity. We want renewables up to 20.1%. Now, why I find this interesting is those two things. When you look at the latest figures, 2024 has not come out yet. Look at what has happened, not through regulatory means, but by the marketplace. Coal now for our electricity generation is down to 16.2%. Renewables are up to 21.4%. And I know this has nothing to do with our lesson, but people are always saying, well, you know, Obama and Biden, they declared war on coal and we're going to bring coal back. I'm going to tell y'all, coal's not coming back. And that's because of marketplace factors. You can see the fall and the decline of coal at the very same time renewables and fracking went up. So what's taken the place of coal is a combination of renewables and natural gas. Fracking is what killed the coal industry, not regulation. Anyway, that's just an aside. So what President Obama had in mind, he said, all right, where are most of the greenhouse gases coming from? Well, a large share coming from power plants. And so we want these power plants to start evolving into the use of renewables more and more and more. Now, we're not going to go to individual power plants and necessarily tell them what to do. We're going to put this burden on the states. And so each state is going to be given a reduction target. You notice Texas was 38%, Arizona was 52%, Washington State 72%. So some of these states had some pretty hefty CO2 reduction targets. And the Obama administration and the Clean Power Plan said, we're going to let y'all figure out how to do this. We just want the end result, and y'all figure out how to do this. And of course, it would be meaning putting regulation on more and more power plants that are powered by coal or other things. Okay. Well, not everybody liked this, of course. And it was litigated and litigated and litigated. It was undone by the first Trump administration. It was kind of put back in an altered form by the Biden administration. But by the time all was said and done, it became a Supreme Court case right here. And the Supreme Court, even though they really didn't have to do this because nobody was pushing this, said, you know, you're not going to be able to do this anymore because of something called the major questions doctrine. In other words, let's say an agency like the EPA has some ambitious plans, and this was. That's a major question. And anytime an agency is dealing with major questions, they have to make sure that their actions, whatever they do, are clearly authorized by Congress. Okay, they can't go general. They have to look at the legislation and say, okay, this is specifically mandated by the legislation. And they said Congress has to speak up and speak clearly if an agency wants to regulate a significant portion of the American economy. This is interesting because, you know, agencies are part of the executive branch, in case y'all didn't realize that. I'm thinking, you know, the executive branch has been doing a lot of unilateral stuff when it comes to tariffs. You think this might implicate the major questions doctrine? We'll see as the lawsuits work their way through the court right here. All right, so there was the background. And then finally, we come to the Loper Bright Enterprises versus Raimondo here that Supreme Court came down with a decision in 2024. Remember what I told you earlier? Bad facts make bad law. Well, this is absolutely an instance of that, and it had absolutely nothing to do with the EPA. So we had a bunch of fishing companies, primarily along the northeast part of the United States, challenging a rule that was established by an organization called the National Marine Fisheries Service. And what the NMFS was making these companies do is pay their own costs for federal monitors to be assigned to their boat. Now, federal monitors had to be on all these fishing rigs. Why? Because they needed to enforce the agency's regulations. And particularly, they wanted to guard against overfishing, which is a real problem. So when you look at the statute that this was all based on, and it was called the Magnuson-Stevens Fishery Conservation and Management Act, it's been around since 1976. It said, okay, if you are a fishery in the North Pacific or you're a foreign fishery, you companies, fishing companies, you have to pay for these monitors to be on board and then report back to the agency. Well, guess what? It didn't say that for the Atlantic fisheries, the herring fisheries right there. The statute was kind of silent about that. Well, for a long time, the NFS had been trying to pay for this, but because of budget constraints, they couldn't do it. So they said, hey, let's just make the industry pay like we do with the Northern Pacific fisheries and the foreign fisheries. Even though the statute was completely silent on that, they developed this workaround and they said, Atlantic herring fisheries, you're going to start paying yourself for these federal monitors. Of course, looking at it, I can clearly see they really didn't have the authority to do this, but it just became a case here. And so as we were watching this case go through, we go, oh my goodness, they're taking a case with really bad facts, and they could give a narrow decision reversing what the fisheries organization did, but it became a vehicle for completely disregarding the Chevron deference doctrine, which, as you know, 3 justices were very outspoken about, and the other 2, Alito and Thomas, would absolutely go along with, and the newest justice would go along with. So here it came to the Supreme Court, and they did absolutely reverse Chevron deference, and they did it on June the 28th of 2024. And here's what they said. They said this violates the APA because the courts need to decide all relevant questions of law here. You know, this credo from the APA about courts deciding relative questions of law, it conflicts with Chevron deference. Hey, it hadn't worked. By the way, it has been working. That's my review right there. And they said Chevron's been limited by recent cases. Yeah, ones that we've been writing that have been chipping away at it. Anyway, so on that day, and to people who follow agency practice when it comes to environmental law or any other type of agency practice, this was a day that we never thought would really come. It was just as shocking to us in the environmental field as the overturning of Roe versus Wade had been. And so now, you know, we are trying to figure out, it's just not yet a year old, and we're trying to figure out what this is going to do. I mean, it's shifting the decision-making powers on technical matters that in past years, the EPA and experts at the EPA have been able to decide. It now shifts it over to the court. I saw one commentator say this is the biggest judicial power grab since 1803. And again, it affects not just the EPA, but all agencies. I noticed this last year, Senator Elizabeth Warren introduced a bill called the Stop Corporate Capture Act bill. And what she's trying to do is codify Chevron deference into law. You know, good luck with that. I don't think it's going to work with this current makeup of the Senate and the House here. So, you know, people ask the question, oh no, you know, is this the end of environmental protection, especially when it comes to environmental enforcement? I mean, look at all the headlines that I showed y'all at the first. We're gutting federal agencies, including the EPA and the Interior Department. So they're not going to be doing it, at least for the next 4 years. And because of this Loper Bright decision, even if they do something that's in favor of the environment, the courts will feel free to second guess them. They've never felt free to do that in the past. Now they will. But we have some good news, or putting a negative spin on it, not as bad news. So let me tell you about a couple of things. One is called citizen suits here, and I call this like having watchdogs at your house. You use watchdogs to watch your property, and citizen suits were set up by Congress for the purpose of keeping an eye on our agencies, especially environmental agencies. So let me show you an example of one, say, under the Clean Water Act. I want to show you this language here. Any citizen can commence a lawsuit here. Against who? Against someone in violation of a limit or an order, or against the administrator of the agency when they fail to act. That's called a citizen suit provision. You're going to find this in RCRA. You're going to find this in the Endangered Species Act. You're going to find this in the Clean Water Act. You're going to find one in the Clean Air Act. And here's how it works. So let's say there's a violation. Well, what's supposed to happen? Let's just go with the EPA here. So the EPA is supposed to prosecute that, right? Do the job they're supposed to do here. And in an ideal world, after enforcement, that violation stops. But let's say the agency doesn't do anything. Let's say what they do is not very effective. It doesn't fit the crime, in other words. So an environmental group, and it can be Friends of the Earth, it can be the Nature Conservancy, Defenders of Wildlife, any environmental group writes what's called a 60-day letter, and they send it to the violator and they send it to the agency there. And that 60-day letter basically says, agency, you've got 60 days to do your job. If you don't do your job, we're going to step into your shoes and do it for you. In other words, we're going to enforce violations of the Clean Water Act. We're going to enforce violations of the Endangered Species Act. We're going to enforce violations of the Clean Air Act. And if they have to do this, say the agency doesn't do anything, they file what's called a citizen suit. Once again, they are doing what the EPA or any other environmental agency should have been doing in the first place. And this is authorized by statute and authorized by Congress. In this, they can recover civil penalties. These are paid into the general treasury. They can get injunctions, in other words, court orders to stop doing certain things. And they can get attorney's fees for the attorneys that they have to hire to represent their organization in doing enforcement. These are called citizen suits right here. And here's just an example. I could pull many up, but I pulled this one up here where Earth Justice was retained on behalf of the American Lung Association and the Natural Resource Defense Council and the Sierra Club to file a citizen suit. So they are sending the acting director of the EPA there that 60-day notice letter saying, if you don't start enforcing your own regulations, we're going to come in and enforce them for you. Those are citizen suits. They've been around for a while. These things are not easy, and there's a whole history. That could be a whole lesson in and of itself. Because do you remember how you get into court? Hopefully you do. Standing, rightness, exhaustion of administrative remedies. 2 and 3 are not too hard for environmental organizations. Standing has been a long time battle, and it's been going on for ever and ever. And there's a whole line of cases. It ebbed and flowed about whether we should be letting more environmental organizations in, or should we be restricting them more. And I'm going to tell you, the latest and greatest Supreme Court case on this was in 2000 here, and it was written by Ruth Bader Ginsburg. which basically said, yeah, as long as there's an injury, in fact, by one of the members, suffered by one of the members of an environmental organization, and it's traceable to the actions of whoever they're suing, we're going to let them on a representational basis come into court representing their organization. So they made it easier for environmental organizations to file citizen suits. And why I'm showing you this is kind of an interesting case that came through the Fifth Circuit in December of this past year. The Fifth Circuit is known as the most conservative court of appeals in the country. And, you know, this was all about illegal air emissions because of upset incidents. And there's benzene, hydrogen chloride, sulfur dioxide, all these other things. This has been a 12-year battle here. And, you know, it all kind of came down to the issue of standing. And so the court has bounced back and forth. But the Fifth Circuit at the last said, yeah, you have standing. You need to organize it a little better. And we're going to give you some categories of violations that cause the injuries, etc. So this is kind of good news that even the most conservative court in the country appears to be allowing environmental plaintiffs to have standing. By the way, they alleged over 16,000 Clean Air Act violations. And initially, they were assessed about a $20 million penalty, and it's been whittled down to 14 million. But this is a pretty major case, and who knows, it may be going before the Supreme Court. But so far, so good when it comes to standing. And if that's the case, so far, so good when it comes to citizen suits. Because if we can't depend on the EPA to do environmental enforcement, a lot of these environmental groups are going to have to step up. All right, here's some more good news here. And I used to say, you know, this is good news for people who leaned right. It's federalism, basically. In other words, we have one central government and we have 50 other governments. And when you talk about federalism, you're talking about states' rights. Here. And so when you look at who has the environmental responsibility in the United States when it comes to environmental matters, the feds and the states have all of this authority. Okay, states have always had it under the general police power, but federal governments delegate a lot of these things to the states. And so we all have our fingers in the pot. And so with cooperative federalism, the federal government has set the floor. In other words, with the Clean Water Act, you say, okay, here are the minimal standards all across the United States that each state has to at least come up to. States, you can exceed it if you want, but you can't dip below. And I'm going to tell you, Texas takes advantage of those minimal standards when it comes to clean air, but we far exceed the federal standards when it comes to clean water. And that's kind of interesting about Texas. But states have an awful lot of power here. And in fact, they've estimated that about 96% of the real environmental enforcement goes on with a state level here. And again, here's the 10th Amendment. And people who were proponents of states' rights were saying, I don't want the EPA or the federal government in my business. Well, guess what? Now we're having more and more people who are keen on environmental protection saying, hey, we're going to ignore what the federal government is saying with this, and we're going to go ahead and enforce this on a state level with the state constitution, state legislation, and state regulations. So that's something that has still remained with us. Any state can enforce its own environmental regulations. And of course, you remember this, Harry Truman signing the APA. Well, every state has adopted the APA. So we still have the agency system going. Ours is found in 2001 of the government code. So when I talk about the environmental practice of administrative practice of environmental law, we deal with Texas all the time. And so this has not changed, and that's good. And I say, hopefully it hasn't. This was in today's Austin American Statesman. I don't know what the Doge bill is going to do. Hopefully it doesn't gut the TCEQ or anyone else who's looking out after the environment. Ironically, You want to, I white it out. You want to see what was on the side? Is this irony? It's just too rich. So anyway, welcome to 2025. This is what we've got. If you want to keep up with the news, of course, go to your usual news source. But like I said, you can go to the regulatory tracker with Harvard Law School, but there's also other trackers, the Brookings Center, the Sabin Center with Columbia University. NYU has a real good one to keep up with plastics. The Washington Post has one. So there's no excuse for being ignorant about these kinds of things. You can keep up with each and everything that's coming through your office. All right, guys, if any of you are still awake, I am absolutely through and I'm going off of this. Anyone still with me here?
Yes, you actually had several people stay with you.
Oh,
And
wonderful. And I should have
I-
mentioned at the first, I'm going to take questions at the last. I'm so sorry. I'm terrible with this because I can't see the questions when I have my PowerPoint up.
yeah, that's okay. That's what I'm here for.
Dawn, will you help me with the questions?
I'm here to help you with the
Thank you.
questions. So if there are any questions, I know that the today's webinar is a bit longer, but I
Okay.
honestly, I didn't want to cut you off. It
Oh,
was
thank
such
you.
great information, and so I really wanted to hear and finish off the thought. And I love how you kind of closed it with a state and what's going on here. And that last snippet from today's Austin American Statesman really kind of
Mm,
is a good closer.
yep.
I don't have any questions in the chat, and uh,
Okay.
I will ask you something myself,
Oh, sure.
and then we'll go close out. And again, thank you all for attending. And
Yes,
I
thank
put this,
you.
yeah, I put the survey in the chat. Please, I see several of you have already filled it out, but if you haven't yet, please fill out the survey. But Neil, I always like to ask our presenters the question of, I obviously you're passionate about your focus in environmental law, but kind of what really drew you to this point, to kind of have this passion. I mean, how many years has it been now that you've been working in this field?
Well, okay, here's the thing. I never thought I would be in environmental law. When I got out of law school, my focus was on criminal law. And so I was a criminal prosecutor and I had my own law practice then after a while, practicing general law and criminal defense. But then it was going back to school that started this. And that's when I went back in the 1990s and got a master's in geography. And as soon as I did that, it kind of opened my eyes. And I thought, what classes did I enjoy in law school? And one of my favorite classes was water law. And so I decided I really wanted to go head first with this. And when I had finished with my master's program, the job opened up with Travis County. And one of the job descriptions was environmental enforcement. And I said, well, there it is. The heavens are telling me it's time. And so, I've just learned stuff from scratch basically over the years, trial and error.
Mm-hmm. Yeah, and as a side note, you all, I originally had met Neil. It was through the Regional Environmental Task Force training that you put on with the Capital Area Council of Governments. And before I came to Spear a long time ago, I worked in environmental compliance, and that's how I met Neil on and doing environmental compliance for water law mainly was with septic systems. Well.
Mhm.
Thank you again for your time and expertise, and those of you who have stayed on. And again, this will be posted onto our YouTube channel with Spear in 3 days. And I hope that you have a good rest of the day. And I have taken a lot from this. I know I have.